In our previous class, in the previous slide, we have been discussing about the service conditions of the judges of High Court, and accordingly, we have discussed certain other aspects like their appointment, their transfers, their retirement, also like their impeachment or removal. So all such things we have discussed. So apart from that, their salaries and emoluments of judges. So what kind of allowances they get, what are the salaries, all such things. So we will discuss in today's class. So their salaries and their allowances, all such things we will discuss in today's class. So like the Chief Justice of a High Court and other judges of the High Court are paid a monthly salary as decided by the Parliament. So here the judges of High Court as well as the Chief Justice of High Court, the salaries and the allowances that they get, so they are decided by the Parliament. So it is already fixed, and they'll be decided by the Parliament. So how much salaries that the judge has to draw, what kind of allowances they have to get. So all such things will be decided by the Parliament, and they are entitled to a rent-free accommodation. So all the judges, along with the Chief Justice, they'll be given rent-free accommodation. So they'll provide quarters kind of things where the judges and the Chief Justice can decide without any payment of rent and other things. So these are all the privileges that a High Court judge or a Chief Justice of a High Court will get. And see, these kind of things they will get during the service. So what about their things after retirement? So they even get a pension. So even after the judges retire, they get a good amount of pension. So the salaries and allowances of the judges cannot be changed to their disadvantage. So that is at any situation, except few that I will say later. So at any situation, the salaries and allowances, that means the extra amount that they get for various purposes and all such things cannot be changed to their disadvantage. So you cannot reduce, you cannot stop them from giving to them. So all such practices is not, they come under the disadvantages to judges, like reducing the salary or stopping the payment of salaries and all. So such things should not be done. It comes under the disadvantage of judges, hence such things are avoided with the case of judges. And so this kind of privilege of not reducing the salary and all cannot be done during the service. Suppose if there is a financial emergency in a country, so where the country is in a crisis, financially it is in crisis, it is in such situations, there can be some changes that can be brought in the salaries and allowances of the judges of High Court. Otherwise, unless there is a financial emergency, we cannot reduce or we cannot alter any changes with the salaries and allowances to the disadvantages of the judges. So, from where these judges will get salaries and allowances? They are charged on the consolidated fund of the state. So what do you mean by consolidated fund? So consolidated fund is something where it is like a government's, play. I mean, it's a government's account, or you can call it as a government's storehouse of all the money, taxes, through taxes how they got and all such things. So that is the money which the governments will get through taxes and all will be generally kept in the consolidated fund of the state. So directly from the consolidated fund of the state, their salaries are given. So one cannot vote upon, like the state legislatures cannot alter the salaries and the allowances that they get simply through any legislative way. So the salaries are coming from directly consolidated fund of the state. Hence, nobody can change their salaries and allowances. So if you look at the consolidated fund of the state here, the tax collected through revenues, non-tax revenue, the borrowings of the state. The central government also will be giving certain amount of money to state governments, their share of taxes. So all such things, they'll be called together as consolidated fund of the state. So the salaries will be drawn by judges and chief justice of High Court from this consolidated fund of the state. There will be consolidated fund even for the government of India separately. So coming to the other factor in the conditions of the service was restriction on the practice. So what is practice here? There, you know, like practice is nothing but suppose if he is a judge, the giving judgment is his practice. If he's a chief justice, same thing will happen. So when there is a restriction on their practices, so when do you think a judge will be restricted from doing his work? So he cannot be restricted when he is in service. Understood? Until and unless there are some charges proved against him and he is impeached, in no other times a judge can be restricted from his practice. But when he is restricted, so I'll describe that. A judge who has worked as a permanent judge. So I'm not talking about the additional and acting judge here. A judge who worked as a permanent judge of a high court can practice after his retirement only in the Supreme Court or in those high courts where he has not served as a judge. Suppose there is a judge, 62 years finished for him, so he will retire. Once he gets retired, he cannot, suppose this particular judge has worked in Andhra, Kerala, for example, I'm saying he worked as a high court judge or he might be even high court chief justice, and 62 years he reached and he got retired. Once he gets retired, this high court judge can work in Supreme Court or he can work in courts other than Andhra and Kerala. That means a high court judge who is retired cannot work in the courts where he has served where he has served, but he can go to Supreme Court and other state high courts. Understood? There he can practice. Let us see in Supreme Court what kind of thing he can do. So already we are saying that he is retired, right? Then how can he go there? Once he is retired, he cannot, he is retired. How can he become judge in Supreme Court? If you look at the term of Supreme Court member, it is 65 years. So High Court it is 62. For a Supreme Court judge it is 65. So once a High Court judge retires at 62, still he has 3 more years, qualification where he can go and work as Supreme Court judge. Otherwise, he can go to other state high courts. See, in other state high courts, if he has to go, he has he cannot go, right, because he crossed the state high court things, isn't it? In a state high court, nobody should stay with 60 more than 62 years of age. Then how can he go for other state high courts where he has not worked by crossing 62 years? Yes, to other state high courts, he cannot go as a judge, but he can practice as an advocate or lawyer only in other state high courts where he has not served. And even in other state high courts, he cannot serve as a judge. He can only serve as an advocate. And he should also not practice in any judicial tribunals. So tribunals are special courts which are appointed especially for a particular purpose. So like water issues between states and all. He is even prohibited from working as a head of a judicial tribunal. In no way after his 62 years of retirement, except in Supreme Court, he cannot function as a judge. Only in Supreme Court he can function as a judge. As Supreme Court's retirement is 65 years, he gets that eligibility. Otherwise, he may not be able to get that eligibility. So, coming to the other conditions. So a judge may, so these are all the conditions still we have discussed. There are certain other conditions that we are left with that we'll see. A judge may resign his office by writing under his hand, address it to President. So as President is the appointee of a judge in High Court, he generally gets appointed by President. He should also submit his resignation by his own handwriting to the President. And the office of a judge of High Court shall be vacant when he is appointed by President to be a judge of Supreme Court or when he is transferred to any other High Court. So, like in two conditions, his position will fall vacant. One is when he resigns. In two situations, a judge of a High Court position will fall vacant. One is when he resigns and he submits his resignation to President. The other situation where it falls vacant is, suppose if a particular High Court judge is promoted to Supreme Court as a judge, then his position will fall vacant. At that time, his position will fall vacant. Or if the judge of a particular High Court is transferred by President to another High Court. So during transfer and during promotion to Supreme Court, only the office of a particular judge in High Court falls vacant. So this is about the other conditions of his services of High Court judges and Chief Justice. So coming to the powers, so after the conditions of service and all, let us now understand the powers and jurisdiction of High Court. So while studying Supreme Court, you have studied about what is jurisdiction and all. So it is the their limit or span of judgment and all. So here, power and jurisdiction of High Court. So the jurisdiction of a High Court of a state extends to the territorial limits of that state. That means a High Court can function within the territorial limits of a state. So India is, union of states. Many states are there. So at every state, suppose you take states with individual high courts, every state high court can function in its own limit. Suppose if this is Andhra High Court, it can function only within the limits of Andhra Pradesh. It is Kerala High Court. The Kerala High Court can function only within the limits of Kerala state. So that is the jurisdiction of a high court. It can function only the territorial limits of that particular state where it is present. And if there is a common high court for two or more states, then or union territories, then the jurisdiction of such a court extends to limits of that states or union states. Suppose if two states is having a common high court, then the jurisdiction of this particular high court will extend to both states. If a high court is present independently for one particular state, that state only will become its jurisdiction area. Or if the high court is common for two or more or one or two states, like two states, then that two states or union territories will become their jurisdiction limits. And so there are there are many kinds of jurisdictions actually. Let us see, among that the first one is original jurisdiction. So what is original jurisdiction? So like Supreme Court, High Courts also have original jurisdiction. That is, the power to hear and decide cases at the first instance. That means anybody can take and go certain cases directly to High Court. So High Court cannot, suppose if some small theft happened in your area, you cannot take directly that issue to High Court. There are certain cases where a person or a petitioner can directly take that case to High Court, and High Court will have power to hear certain cases for the very first time without going to any lower court. So that cases can directly reach High Court. For example, you take your fundamental rights. If they are violated by any agency in government or any other agency, you can directly take those case to High Court. No need to take to lower court and from there to next higher court. No need of all such. So such all cases come under original jurisdiction of High Court. For the very first time, that case will be directly heard in the High Court. Such power of High Court is called original jurisdiction, and it has original jurisdiction in the following cases. So High Court exercises its original jurisdiction in the following cases. Like what cases? Over matters relating to state revenue and its collection. So state gets income and revenue through various ways, like taxes, non-tax revenue, or through central government. It gets income through various ways. If there are any issues with such revenue and the collection of taxes by or the collection of revenue by state, such cases can be directly taken to High Court. So there, no need to take to lower district court and next other court, and no need all such process. And cases regarding wills, divorce, and marriage. What do you mean by will here? So will is nothing but a legal right of a person to give his property and other things to the next generation of his family. So like Vilunama we call. So wills are nothing but it is a right of a person to give his property to next generation of his family or whomever he wishes. So if there is any dispute over wills of property, such cases can be directly taken to High Court. Also, divorce cases, cases related to marriage, company law. So what is this company law? So three or four people, they may come together and they may start a business, and they may get some problems later on. I know legally they get some problems and all regarding their agreements and all such things. During such situations, company law will be applicable, and all such cases related to company law can be directly filed in High Court. Contempt of court. That means if anybody disobeys or disagrees with the judgments passed by High Court, if any outside agencies or persons, it comes under contempt of court. Such cases also can be directly challenged in High Court. So, such cases of contempt of court, sometimes the High Court takes it directly, some other times somebody may take that cases to the notice of High Court. So this is about the original jurisdiction and its introduction. So under the original jurisdiction power of High Court, what are the other things that are covered that we are going to discuss in this slide? So every High Court has the power to interpret the Constitution, and this power is known as power of judicial review. See here you have to understand one thing. So here, what do you mean by High Court power to interpret the Constitution? See, generally what happens is Parliament, or leave apart Parliament here, you take state legislature, that is the assembly. So what is the function of the state assembly? They have to make the laws. So when these state legislature make laws, they should be under the provisions of Constitution. So they cannot exceed the limits of the Constitution and can make laws. So any legislative body which makes laws beyond the provisions of Constitution or crossing the limits of the Constitution, then in such cases the High Court in a particular state will try to protect the Constitution by interpreting it, by interpreting the laws made by a particular state assembly or legislative body will be interpreted, and this interpretation power of a High Court on the laws made by that state legislature or any executive order is referred as judicial review. So is nothing but a reviewing of the laws made by state legislatures. So if anybody brings the issue of any law made by a state legislature to the notice of the High Court, then High Court can review that law. So for what purpose it will review the law? It will only check whether that law is constitutionally valid or not. So that power of High Court is called judicial review. So such cases can be directly taken to High Court. No need to file the case in the lower court. So such power of High Court to review the laws made by state legislatures for the constitutional validity is referred as judicial review, and it comes under the original jurisdiction of the High Court. And along with the Supreme Court, it enjoys original jurisdiction for the enforcement of fundamental rights by issuing writs. So we have studied in Supreme Court about writs, right? So habeas corpus, mandamus, isn't it? So all such things are writs. So writs are orders given by courts for the enforcement of laws or the fundamental rights for citizens. So like Supreme Court, High Court can also issue writs. So when can it issue writs? When the fundamental rights of the citizens are violated by the state governments or any other body within the limits of the state. So here the high courts directly take up such cases where the fundamental right are violated. So no need to go here also for lower courts for getting your rights done. So that is also under the original jurisdiction of the High Court. So one is judicial review, the other is issuing writs for the fundamental rights enforcement in case if they are violated. That also under like original jurisdiction. And the High Court has original jurisdiction in cases such as election petitions challenging the election of members of parliament or a member of state legislative assembly or local bodies. So here, suppose a parliament member got elected from a place in that particular state, or you take any MLA got elected from a particular area of that state, or a local body, like maybe like district wise they have ZPTC, MPTC kind of local body posts and all. Any of the If there is any dispute over the election of an MP in that state or MLA in that state or any person belonging to local bodies, then all such cases are called election petitions. So any dispute over that, or if any you know thing they want to get clarified and all, such petitions can be directly. Suppose if somebody has produced wrong documents and got elected as an MP, something like that, any fraud they might have done and they might have got elected. So all such cases related to an MP, MLA or local body elected person, they can be directly filed in a high court. So the high court takes such cases regarding election petitions through direct or original jurisdiction. So coming to the appellate jurisdiction. So in Supreme Court also we have studied this topic. So like if so I'll just remind you what happened like with Supreme Court. Supreme Court has appellate jurisdiction. That means any person who filed a case in High Court and he is not satisfied with the judgment of High Court, he has certain right to appeal to Supreme Court both in civil and criminal cases. So the same way, High Courts also have appellate jurisdiction. That means from the lower courts or district courts, case if the petitioner is not happy with the judgment, either it may be a civil case or criminal case, he can approach High Court in the form of an appeal. So such power of hearing cases from the lower court or subordinate courts like district courts, Such power of High Court is known as appellate jurisdiction. So in the form of appeal, so cases may even reach to High Court. So here, High Court can accept such cases which are coming from district courts in civil as well as criminal cases. So generally, they come from the district appeals come from district court to High Court. So both in civil as well as criminal cases. So in that, let us begin with our civil cases. What are civil cases? Like, civil means like civilians, like common people. So they have, under civil cases, you will get like family issues, property issues, so all such things. So all such cases can be referred as civil cases, and certain kind of civil cases will be taken up by High Court under its appellate jurisdiction power. Let us see what are those things. So, any civil case can reach to High Court by an appeal, and appeals can be brought to the High Court. In matters concerning the land revenue, so generally what kind of civil cases can reach High Court through appeal? In terms of the land revenue, okay? So the amount of income that can be generated from a particular land is called land revenue. So that if there is an issue with the land revenue and that issue has not been addressed, that means that issue has got a different judgment in a district court, and if the petitioner is not happy with the judgment passed by district civil court, then he can approach to High Court as only on land revenue issues. And in case where a blatant injustice has been committed by any tribunal, such cases the High Court may quash the order of tribunal. So I said that tribunals are special courts which function only for a particular issue-based courts like water disputes between states, all such things. If any tribunal has given blatant injustice, that means they have not gone through properly the evidences and other things. I know they have committed a serious mistake in giving the judgment, and there was a severe loss for the person who has been, charged. During such situations, we can take the matter from tribunal to High Court. So the High Court should convince that the judgment given by tribunal is completely non-evidential and no injustice has been done. If High Court convinces that, then from tribunals it accepts cases in the form of appeals, or cases of land revenue will also reach to High Court in the form of appeals. So that is another situation. So that is about the civil cases. So in two kinds of civil cases, like land issues and other, if injustice has been done through tribunals, then such civil cases can be directly taken to High Court. They can be taken in the form of an appeal to High Court. So coming to the other cases called criminal cases. So you know what is criminal cases, where crime is involved. So what kind of criminal cases can be taken through a form of appeal to High Court? That we'll see. Against the judgment of a sessions judge or additional sessions judge where the sentence of imprisonment exceeds 7 years. So here what happens is, generally on a crime, who will deal the criminal cases at district level? So these are the criminal courts. So the judge who deals criminal cases at district level is called sessions judge. To assist him, there will be an assistant or additional sessions judge, or not, due to cover up the pending cases, there might be an additional sessions judge. So when a sessions judge or additional sessions judge passes a judgment on a crime which exceeds, I know that judgment or that punishment exceeds imprisonment of more than 7 years, there is a sessions judge, or we have additional sessions judge, and he passed a judgment on a crime. So this crime was given a punishment of more than 7 years. Then such punishments given by Sessions Judge of District Criminal Court can be made can be appealed to High Court, saying that my punishment of imprisonment is not lawful. So in any way, the petitioner can take such cases which has more than 7 years of imprisonment in the form of an appeal to High Court. And against the judgment of an assistant sessions judge, the chief metropolitan magistrate, or other judicial magistrate. See, like sessions judge, even assistant sessions judge works on the criminal cases. So if an assistant sessions judge or the chief metropolitan magistrate, see, metropolitan areas are nothing but they are not as small. See, they cannot be given a district status, but at the same time they have more population too. So they are called metropolitan areas with huge population, but they cannot be given the status of district also. The bigger cities, if you call. For such bigger cities, the criminal cases will be dealt by metropolitan magistrate, and the judgments passed by an assistant sessions judge or a metropolitan magistrate, if they give a punishment of more than 4 years of imprisonment, then during such situations, the person who got punishment can appeal to High Court for justice and whatever it is. Also, against the state when the order of acquittal is passed by a sessions judge. Suppose if the sessions judge passes an acquittal order, that means the person who is involved in crime is declared guilty. That means he is not involved in the crime, he is innocent. That declaration is called acquittal. If a sessions court declares a person as guilty of the crime, then during such situations also, against the other party, we can go to High Court for, in the form of an appeal. And a sentence of death must be confirmed by High Court before it can be carried out. Suppose if a district criminal court awards a death sentence to to a person who has involved in crime for getting proved, if it awards a death sentence, it cannot implement it, because if a sessions court gives death sentence, then it must be informed to High Court, and after the approval of High Court, then this death sentence can be implemented. So anybody who got death sentence through the sessions court at the district level can appeal to High Court, and only after the High Court's permission or approval, then the death sentence can be implemented. So this is about the criminal cases through appellate jurisdiction.